Okay, we're going to get started here. I know that we are having some technical difficulties, and I apologize for that. Welcome to today's webinar. Just hold on for 1 second. Good afternoon. Welcome to today's webinar, Pitfalls in Construction Contracts, a 1-hour interactive webinar which will focus on basic issues both plaintiffs and defense attorneys can incorporate into their practice. During the presentation, our presenter will cover the following topics: project delivery methods, claim generating occurrences, and the 5 pitfalls of construction contracts: incomplete bids v. viable bids, changes v. managed changes, unreliable site presence v. reliable site presence, ambiguous schedules v. monitored schedules, and incomplete closeout procedure v. careful closeout procedures. Our today's presenter is Robert J. Illo, AIA, PE. He is the Principal Architect and Engineer for Architecture and Engineering Innovations, located in Mountville near Lancaster, Pennsylvania. Mr. Illo holds an architectural license in several states, as well as a civil structural engineer license in several states. Mr. Illo has over 25 years of experience in architecture engineering, forensic evaluation, and restoration services for residential, commercial, industrial, and public property design. He has been called as an expert advisor and witness in numerous property, safety, and construction litigation cases, serving plaintiffs' counsel, defense counsel, and insurance companies. He continues to provide accurate forensic evaluation and remediation measures in matters involving the built environment. Mr. Illo is a member of the National Trust for Historic Preservation, the National Society of Professional Engineers, the National Council of Architectural Registration Boards, as well as the American Institute of Architects. He holds a Master's of Engineering and a Bachelor's of Architectural Engineering from Pennsylvania State University and a Bachelor of Architecture from Drexel. If you have any questions during today's presentation, please use the chat or Q&A feature, which is located on the right-hand side of the page. We'll do our best to answer the questions during the presentation. Approximately 1 hour after the event, we will send out an email with a link to the archive recording of the webinar. We do ask that you take time to fill out the survey that will appear on your screen after the webinar is over. I want you to sit back, relax, and enjoy the presentation. I'm now going to turn things over to Bob. Bob, it's all yours.
Well, thank you very much, Matt, and thank you all for joining us this afternoon. I appreciate the opportunity for you to join us in this discussion about pitfalls that are found in construction contracts. I'd just like you to ask you that while I'm talking, to take a minute to type in, if you would, a brief description of your area of practice to help me get an idea of what your needs are, what type of work you do, and I can better address your needs with my presentation. First of all, I'd like to say that the word the article the before 5 is a misnomer, since there are plenty more than 5 pitfalls in construction contracts, but today I want to go over 5 that cover a pretty broad territory. Before we get into the pitfalls, I will briefly review contracts and project delivery models and claim-generating occurrences associated with them that can develop in construction projects. A construction project can be delivered in several ways. The term project delivery refers to the relationship between the 3 major parties to a construction contract, namely, number 1, the owner or developer, number 2, the architect or design professional, and number 3, the contractor. For example, 3 common project delivery models are number 1, design bid, Number 2, design build, and number 3, construction manager. These are not the only three, but they are three common project delivery models. In a design bid delivery model, the architect forms a relationship with the owner prior to the selection of a contractor. Through this relationship, the architect works in the owner's interest to develop plans and specifications with sufficient detail to obtain a building permit, number 1. Number 2, to obtain competitive bids from contractors. And number 3, to serve as binding criteria during construction. The second model, design-build delivery model, is one in which the owner forms a relationship with the contractor to determine the size and cost of the building project, often called the Guaranteed Maximum Price, or GMP. Now, with the GMP established, the contractor then retains an architect to prepare plans and specifications that fall within the GMP. The contractor uses these plans and specifications developed by the architect who works for him to construct the project, using whatever subcontractors and suppliers allow him to stay within the GMP. Contractor here, in a design-build delivery model, usually is paid by taking a markup on materials and subcontractors' costs, which are included in the established construction cost, or is paid by the difference between the actual cost and the GMP. The third model that's common is a construction manager delivery model. In this model, the owner forms a relationship with the construction manager who will not necessarily perform the work. The construction manager does not mark up construction costs. Rather, he charges a fee and establishes a guaranteed maximum price for the project. The construction manager may retain an architect, or the owner may retain an architect to prepare the plans and specifications. Now, the construction manager presents price quotations for materials and subcontractors to the owner during construction, allowing the owner to select these components of the project. The construction manager will advise the owner of the impact of these selections on the GMP. Now, many variations of these models are used, but today's discussion is structured around the design bid project delivery model, although most of the ideas we'll discuss are analogous to the other delivery models. I'll also limit today's discussion to the construction phase of a building project, saving the planning and design phases for another day. In our current economy, property owners are more frequently using construction manager or design-build delivery models rather than hiring an architect, under the mistaken belief that these choices have the effect of saving the cost of an architect. But in fact, the architect's fees are still paid by the owner under these models. The owner is not directly contracted with the architect, however, and this is an unfortunate disconnection because the architect is the only member of that three-member team that has no financial incentive to cut corners on construction quality. So you'll be getting an architect's view, certainly, of the 5 pitfalls of construction contracts and all the topics we give you today. And as an architect, of course, it's my view that an owner who hires a contractor to manage his building project is like an attorney who relies on the court reporter to formulate questions for the witness during the trial. In any case, all construction projects have the potential to generate claims. So let's take a look at some common claim-generating occurrences. Number 1, anyone who has represented a developer, contractor, or design professional knows that construction projects are, in fact, claim-generating machines. By recognizing claim-generating occurrences, attorneys can better help their clients avoid exposure and prevail in either putting forth or resolving construction-related claims. So construction claims can prevent a project from meeting the owner's monetary or budgetary objectives, even jeopardizing the completion of the project, leading to financial disaster in the worst case for owner and or contractor. The following occurrences can lead to construction claims, as you see on the screen. Number 1, poor work quality. Number 2, cost overruns. Number 3, delays in schedule or in delivery of portions of the project or all of the project. Number 4, default, of the contractor, where the contractor fails to be financially viable and goes out of business during the project. Number 5, injury on the site. And number 6, damage to the property or to the structure. At this point, I'd be happy to take a moment to answer any questions that you might have about what I've covered so far. So if you'd like to take a moment just to type in the chat space, I'd be happy to address any questions about what I've covered so far.
Bob, actually, I had a question come in to me. Why would the architect be less able to control construction quality in a design build or a construction manager arrangement?
Yeah, well, again, I'll give you the point of view from an architect's point of view that as an architect, when I'm working for a contractor in a design-build relationship, I'm one step removed or one person removed from the owner or the end user. The contractor is writing my checks and paying for my work, so I'm not much of an advocate for or as effective an advocate for the owner as I am for the contractor. The same with construction management. If the owner hires me rather than the construction manager hiring me, things are a little bit better in that case. But in any case, there is a disconnect between the architect and the owner.
I had another question come in to me here. Can you give an example of how project delays can lead to claims?
Well, sure, Matt. Obviously, there's a strong connection between time and money. So if a project is delayed by even a short period of time, the contractor still has mobilization costs. Even though he's not installing more material, every day and every month that goes by costs the contractor to hold a field office, to keep the books on the project open, to be paying whatever financing on his line of credit for materials and labor. And so all of those costs continue. And the unfortunate thing about those costs is that they do not result in any added value to the project for the owner. So the contractor has two choices. He can swallow it and take the loss on his own shoulders, or he can pass the cost on somehow to the owner. Usually the way a contractor passes that cost on is by making a claim. Since the owner is not very receptive to paying for something that doesn't result in added value. If the owner can be found to be responsible for the delay, then the contractor is more likely to prevail on such a claim.
Excellent. Bob, I have a question here from David who asks, what about owner cost for contractor delays?
Yes, owners certainly can incur costs if the contractor delays the delivery of the project, or even if the contractor delivers the project too soon. For instance, if a building is built early, the owner has drawn down all of his construction loan, is now paying full financing, so he's got an incentive to move into that building and begin operating costs on that building, but may still have an obligation with the past building. Of course, your question, Dave, is about delays on the part of the contractor, and that certainly would cost the owner money because the owner may not be able to use the facility right away. In the worst case, let's say a manufacturing facility is being constructed. I had an owner in Cleveland years ago that had an order that they promised to an owner for ice cream. And in order to satisfy that order, by November they had to be producing the ice cream and shipping it out. And the project didn't come in until after November, and they lost that contract. So there they had a building and no customer to produce product for, and they had to hit the streets and find another customer. And that took many months, so there was a lot of cost to the owner for that delay.
Excellent. Thank you, Bob. I don't see any other questions, so we should probably move forward with the continuation of the presentation of content.
Okay, very good. Well, with the occurrences that I listed earlier, claim-generating occurrences in mind, I will now move on to outline 5 pitfalls. And again, these are not the only 5, but 5 pitfalls that can lead to claim-generating occurrences. These pitfalls are common to construction projects regardless of the project delivery model or the form of the contract. Quite often, the construction contract is taken in the form of a stock document, and it's bent or twisted and cajoled into suiting the needs of a specific project. Other times, owners use the contractor's favorite contract. But whatever the form of the contract, the provisions that it contains are only as effective as the diligence with which the parties to the contract carry out those provisions. Common pitfalls are a function of how clear those provisions are in the contract and how well they're observed. The first pitfall is one I call bids gone bad. This pitfall presents itself before the shovel hits the ground. Several practices can prevent bids from going bad, and the first one is to communicate thoroughly during bidding. The purpose of the drawings and the specifications is to supply all bidders with identical information. Despite this intent, information is routinely requested by bidders during their preparation of the bid, as they should be doing to make sure they fully understand the drawings and the specifications. A bad bid can result, however, if one bidder's question is answered without providing both the question and the answer to all the bidders in writing in time for all the other bidders to incorporate that information into their pricing. So thorough communication is essential. A second practice that avoids bad bids is to evaluate bids thoroughly. Not all bids are created equal. Even though all bidders have been asked to bid on identical project criteria, not all bidders are willing or able to accept the terms of the contract. These bidders will include qualifications, substitutions, or exclusions with their bids. When bids are received, which include these project-altering provisions, the owner has the option of evaluating the bid to determine if the provisions are acceptable or rejecting the bid. Now, either of those two options has legal consequences, and the contract should be written to allow the owner to respond in a way that is fair to both the owner and to the bidder. Control allowances. Contractors often cover the cost of a portion of the project by listing a cost allowance for that item rather than including the item in its bid. Allowances are often used when the type or the quantity of an item cannot be determined prior to construction. For example, the owner may request an allowance for ceramic floor tile to allow the size and the style of the tile to be selected during construction. Or the removal of subsurface rock could be an allowance because subsurface rock cannot be seen or quantified prior to excavation during the time that the bids are being prepared. So allowances give the owner flexibility, but if handled incorrectly, they give the contractor a blank check at the owner's expense. The contract should specify for which components of the project the owner will accept allowances, specifying the dollar amount when possible. For instance, the contract could be written that rock shall be priced at $5 a cubic yard, and you are to assume that there are 100 cubic yards of rock to be removed. Anything more than that, we pay you $5 over. Anything less than that, $5 is deducted from the contract. All other items that can't be done in this way or handled in this way should be specified so that the bidder can be required to include the cost in its bid. Next, know when to rebid. If the bids are not responsive or the budget cannot be met, the contract should allow the owner to rebid the project. Now, the process of rebidding is time-consuming, it's costly, and it should only be viewed as a last resort alternative to awarding a contract to an unqualified bidder. Next, establish a construction schedule or adhere to an imposed construction schedule. It's advisable to write the contract to allow the bidders to submit a schedule with its bid, or with their bids, because each bidder has an optimum time frame during which it can deliver the project in the most economical way. If meeting a deadline is more important than saving money, then maybe that kind of flexibility is not a good thing in the contract, and the contract should reflect this need by establishing a not-to-exceed completion date, but allowing bidders who can finish a little earlier to do so. The second pitfall is caused by changes. Changes can cause problems in several ways. Number one, a practice called horse trading is often used on construction projects, and it should be avoided. The term horse trading refers, of course, to the practice of an owner allowing a time-saving or cost-saving change at the request of the contractor with the hope that the contractor will reciprocate by adding value to the project without charging for it. For example, an owner may allow the contractor to install less expensive window units that are more readily available in exchange for a few more shrubs along the front sidewalk. Now, the danger in horse trading lies in each party's perception, that is, owner and contractor both perceive that the concession they have given is of higher value than the concession that has been made to them. Owners can avoid this problem that horse trading causes by adhering to the change order process. In other words, specifying changes to scope, schedule, or cost in writing and getting authorization before proceeding. Next, control scope creep. Often the scope of a project creeps over time, and usually the owner is at fault for that. Often the owner wishes to add elements to a project after construction has begun. Even if these additions are introduced through the change order process, the cost of these changes can escalate to threaten the stability of the project, as well as impose a strain on the relationship between the owner and the contractor. The best antidote to scope creep is to include the owner's wish list in the plans and specifications during the design phase and omit those items not supported by the budget that are less important to the owner. Of course, that has to be done by the architect, and it takes place before the construction contract is written, and it is always far easier said than done. Next, manage the or equal provisions. Some people say the scariest words in a contract for construction are or equal. And yet most specifications allow the contractor to use a material that is equivalent to the specified product to give the contractor more control over cost and availability, for instance. When equivalent products are allowed, the contract should require that the contractor would submit sufficient data about the product to allow the design professional to evaluate its suitability. In other words, is it equivalent or isn't it? Likewise, specifications should contain sufficient detail to afford the design professional an objective basis for evaluating a proposed equivalent product. Also, issue realistic clarifications. Contractors often request a clarification of the drawings that lead to details. You'll see the little box for details down at the bottom referring to that idea. For instance, the drawings may not contain a detail for flashing around a roof ventilator. Although the drawings and specifications are clear that the roof is not to admit water, the means by which this requirement is met by the contractor may not be clear. So in this case, the architect can issue a flashing detail that's consistent with manufacturer's requirements to help the contractor out. On the other hand, a civil engineer might notice that stormwater runs off his parking lot and onto the adjacent property, and he may be tempted to add a curb to the edge of the parking lot to direct the stormwater to an inlet, for instance, and he'll do this by issuing a drawing that, quote, clarifies the edge of the paving condition. Now, if this clarification of the edge of paving includes a curb that was not shown on the bid set of plans, the engineer can expect that the contractor will thank him for this clarification by sending a request for additional funds to pay for the curb. So in short, the field clarifications should not add scope to the project, but they can be a useful tool in helping the contractor to accomplish the project requirements efficiently. That brings us to the third pitfall, which I am noting is caused by unreliable site presence. It's very important to point out before we talk about the owner or the architect setting foot on a construction site, to point out that contracts should always name a single individual who will serve as a representative for the party to each contract. when referring to an individual in this discussion, the words owner, architect, and contractor mean the named representative in the contract. The contractor may have more than one representative. For instance, a project manager who would take care of administrative issues associated with construction, and a site superintendent who is on the site every day, each of whom represent distinct portions of the contract, and their distinct responsibilities should be clearly delineated in the contract. So the contract for construction necessarily gives substantial control of the construction site to the contractor. Contracts should also establish who may appear on site and who must appear on site and how often. Usually the owner and the architect are assigned certain site visiting roles. So let's look at the owner's role first. The owner's role on the construction site should be severely limited. The contract should spell out that the owner is well advised to study the limitations and observe the contract limitations during site visits to the construction site. Ideally, the owner should have no material or procedural role on the construction site. Now that seems obvious, although I've had many owners who felt they could save money by self-performing work, like installing their own fencing, by supplying their own materials to the site, or bringing in their own subcontractors to handle portions of the site. These owners should be handled with extreme caution. If possible, enlist his wife, his children, a family pet to discourage him from these self-defeating practices if your best efforts fail. However, the owner's involvement on site should be written into the contract with clearly defined limitations. Now contrast this to the architect's role on site. The standard AIA agreements between owner and architect are synchronized with the standard AIA agreements between owner and contractor to establish the architect's role on the site. Any family of contracts that are written not based on AIA agreements should consider synchronizing these roles. The role of the architect on site includes periodic observations and very little else. When the architect is on site, the architect should coordinate its movements with the contractor's site superintendent. In other words, give notice before you show up at the site if you're the architect. Surprise visits work better for television plot devices than for smooth construction projects. So how should the architect address a question when he's on the site regarding construction means and methods? While the plans and the specifications outline fairly extensively what the responsibilities are of the contractor, they outline the construction results rather than the means by which those results are achieved. The means by which the results are achieved are largely the responsibility of the contractor. So the owner and the architect are well advised to refrain from suggesting the manner in which work is conducted and should resist answering any questions put to them while on site regarding the means and the methods. Also, owners and architects should avoid shooting from the hip when they're on site and ask the question. Often the contractor will request information from the architect using a familiar phrase, "Hey, as long as you're here," as a pretext. Now the architect has to resist playing the role of the omnipotent wise man and answer these questions immediately on site. Rather, the architect should go back to the office and duly consider his response after an examination of all the construction documents and even a consultation with the owner. It's important to understand that a problem that is presented to an architect on the construction site would have existed even if the architect had not visited the site that day. And in that event, the contractor would have done what the contract requires and sent a written request for information and then waited for the architect to respond. So if an architect or owner finds himself on site and being bombarded with questions by the contractor, the site superintendent, or anyone else, the protocol should be to return a written response or to ask for a written question and then respond to it in writing. How should the owners deal with subcontractors is often a question that comes up, and it's fraught with problems. While on the site, the architect or the owner might be approached by a subcontractor, by a supplier, by a laborer, by the guy who delivers sandwiches to the site, etc. So both of them should observe the cardinal rule, as I call it, that communication regarding the substance of the contract should be made only between named representatives of parties to the contract. So how should the owner handle code inspections? When a code official visits the site, her job is to find departures from the code. If the departure from code is inherent in the design, the architect would have exposure in that case. If, on the other hand, the departure from code is a result of deficient construction practice, then the contractor would have some ground to cover. Code deficiencies can lead to claims against the owner by the contractor regardless of whose fault it is, because code deficiencies lead to costs and delays on the project, and costs and delays, regardless of whose fault it is, lead to claims. So because of this potential, the architect can review and should review the code inspector's reports and address each of the items on the report in writing. In addressing the corrective measures, the architect can and should challenge the code official's interpretation of the code to avoid making a costly change to the project that is not strictly required by code, or that can be made to conform to the code in a manner that's less costly than the code official may recommend in its report. For instance, a code official may correctly point out that a wall which encloses the boiler room should be rated for 2 hours, and the 1-hour stud wall that the contractor built according to the architect's plans should be torn down and replaced with a concrete masonry wall. This remedy can be challenged by proposing to add 1 layer of gypsum wallboard with the appropriate number of drywall screws and save time and cost and limit the potential for a claim. What about field testing? Field testing can often lead to unforeseen costs. Unforeseen testing requirements can cause a burden to the project. So the contract, in conjunction with construction documents, should identify which party schedules the tests, which party retains the various testing agencies, who's responsible for tests required by the permitting authority, which tests are required by the owner, what specific materials and assemblies will be tested, and the testing frequency. Testing that is to be included in the bid must be defined with sufficient detail to allow the contractor to accurately price the testing services. And the last idea that I want to cover under site presence is the idea that if you own it, or if you see it, you own it. This concept can apply to the quality of the work as well as to the safety of the working conditions, and it can cause both the owner and the architect to be shy about setting foot on site. Most contracts clearly relieve the owner and the architect of responsibility for the quality of the contractor's work and for the contractor's safety practices, so that those parties, the owner and architect, are able to set foot on site and observe construction progress without relieving the contractor of its responsibility for controlling on-site operations. Now, most contracts also contain language that would prevent the owner or the architect from ignoring an obviously dangerous condition. For instance, if an architect is on site and he sees workers on a high platform without fall protection, or sees contaminated water being added to the concrete to make it more workable, the architect would have a duty under most contracts to bring these conditions to the attention of the contractor and call for corrective measures without relieving the contractor of its responsibility for safety and quality. So those are all the ideas I have associated with site presence. And before we get to the next pitfall, I wanted to just let you take a moment to type in any questions that have occurred to you while I've been talking about anything we've covered so far.
Bob, we do have a question from David who asks, what do you feel about using unit prices to help prevent allowances from running amok?
Yeah, David, thank you for the question. Question is, how would unit prices prevent allowances from getting out of control? And there is a relationship between unit prices and allowances in that they both are used to cover uncertainty in the project. So for unit prices, the uncertainty typically is over quantity. And so just comparing the two, unit prices would help us overcome an uncertainty for quantity, and allowances help overcome far more uncertainties, quantity or quality or style or type. For instance, allowances are often used for carpet, where the owner has no idea if he's going to buy $1 a square yard carpet or $30 a square yard carpet for certain parts of the building. So keeping that in mind, using unit prices can keep allowances down by having more products or more parts of the construction contract covered by unit prices and fewer that would have to be covered by allowances. The way to do that is to pin down the quality and the type of the material to be used. For instance, a unit price could be used for carpet if the carpet is specified, but the owner's just not sure how many rooms he wants carpeted. That way you've eliminated a lot of variables, and you can compare the unit price that's given by the contractor. And there are two ways to do unit pricing. One is to say, thou shalt use this as a unit price, or you allow the contractor to put a unit price in and compare the unit prices based on, say, 2,000 square feet of carpet, if unit prices are used for carpet, for instance. That way you've eliminated all the variables but one, and the only thing that could possibly change is quantity, and you're not doing it at an unbid price. Did that answer your question, Dave?
We have a question from Catherine who asks, if the architect engineer observes faulty work, is the contractor relieved of its responsibility to build in workmanlike manner if it is not brought to the contractor's attention?
Ultimately, I would say no, and the reason I hesitate on that is because there are two forces at work. One is the way the contract is written, and the other is case law. Typically, contracts are written to establish that the contractor is responsible for the quality of work, and the architect's role is not to be a watchdog or a supervisor. Whereas, the way the contracts can be written to reinforce that is to use the word observe rather than inspect or rather than supervise. Certainly, you'd never want to use the word supervise in association with the owner's role on site or the architect's role on site, but to limit those roles to making observations. And then on the other side of the issue, Catherine, to reinforce that the contractor has control of the site, number one. Number two, has responsibility to be aware of all the practices that are taking place on the site by subs and others.
Great, and you did. David indicated that you did answer his question, so thank you, Bob.
Thanks, Dave.
What are some examples of unresponsive bids?
Well, an unresponsive bid is a very, very broad term, and what it often is in dispute. In general, the definition would be a bid that does not accomplish the goals that are expressed by the plans and the specifications. So let's take a trivial example of a house with a full basement that the owner or the architect puts out to bid, and the contractor says, well, I know there's rock out there, so I'm not going to bid a basement. I'm going to bid a crawl space or a slab on grade, and they put their bid in that way. The owner says, I don't care how much rock is in there. I want to store my books in the basement, and so we're going to have a basement one way or another, and so the bid's not responsive. It gets a little more complex when talking about substitutions that the contractor may offer. So the gray areas for unresponsive bids would be different products or different means or methods of accomplishing the work. And when I say means or methods, I don't mean that in the sense of means or methods that don't affect the result. I mean, for instance, on a paving project, if they are to compact by different means and the engineer knows that that means of compaction will not achieve the 95% dry density, then it's an unresponsive, it could be said to be an unresponsive bid.
Okay, great, Bob. Just one more question. Are there ways to eliminate changes in a project or at least control them? Is there a set of best practices that you would recommend?
Yeah, very often I have owners say at the very beginning of the design project and at the very beginning of construction after everything's bid that there will be no changes on this project. And then, of course, the first person to request a change is the owner. So it is a good question, and I don't know that construction science has yet figured out how to get owners not to change their mind. I shouldn't blame owners all the time because very often changes are initiated by the architect and by the contractor, and I guess eliminating them comes from understanding what the causes are. And in almost every case, the cause can be brought back to indecision or misinformation. So if something is not understood about the contract project or about the construction project, then that will lead to a change. For instance, something as benign as hitting rock below the surface, that would cause a change in the scope because now there's rock removal and there's a delay of 4 weeks in the project, to something like the owner would pick a certain type of wood to be used in the trusses, and the trusses are exposed and the owner just doesn't like the way they look when they arrive on site. So architects can help by giving samples or by putting in the contract that portions of the work will be shown to the owner before the owner approves to use them. That would eliminate some of the second guessing that happens with an owner. A very common provision for that is in masonry work. Masonry involves clay or stone products or even concrete products that have lots of varied colors and textures used with mortars of different colors. And so requiring the contractor to build a panel that is, say, 5 feet wide by 4 feet high so that the owner can see what it all looks like together is a prudent provision.
Excellent. Well, I don't see any more questions in the queue, so we should probably move forward with the presentation of content.
Okay, very well, and I appreciate your questions. So I'd like to talk about the fourth pitfall, and I call the fourth pitfall ambiguous scheduling. And there are two things that can lead to ambiguous scheduling. One, the schedule is not clearly defined before work begins, and two, the schedule is not monitored after work gets underway. So if work falls behind schedule, cost overruns are inevitable because time is money. And here are some practices that can help avoid ambiguous scheduling. Number one, field verify the progress of the project. Sounds simple, and it is fairly simple. Number one, establish a procedure for observing progress on site. This could be bi-weekly if it's a complex and large project. Could be once a month. But in any case, establish the interval and the procedure for observing progress and for quantifying that progress relative to the schedule that has been established. One way to quantify it is to have the contractor include in its bid a schedule of values for all the portions of the contract. So the more detail into which the components of the project are broken down, the more easily each component can be quantified by making site observations, either the owner's representative or the architect making those site observations. Second, obvious way to avoid ambiguous scheduling is to require a schedule. And that seems very obvious, but it's surprising how many contracts get awarded without anything more than a completion date. And the contractor starts work without having submitted a schedule. Contracts should require a contractor to submit a schedule with its bid, and that schedule should include milestones. The contract should require the level of detail in the schedule that's appropriate to the size and the complexity of the project. If the schedule has too many milestones, for instance, it becomes too difficult to manage. If it has too few milestones, there's a risk that a slip in the schedule will not be picked up until it's too late to take corrective action. Third idea associated with scheduling is to be careful about reviewing the progress payments. Contractors will apply for progress payments on a monthly basis, typically, more often if it's a large project. And their application for progress payments should be compared to the work that's in place on the site. Some contracts allow a percentage of payment for materials that have been purchased and stored either on-site or off-site. This is dangerous territory, but contracts can allow it under certain conditions. If any stored material is eligible for payment, it should be materials that are certain to be incorporated into the project site, such as custom fabrications that couldn't be used anywhere else. Next, allow certain delays in the contract. Most contracts will allow the schedule to be extended under certain conditions that are beyond the control of the contractor, like weather. The conditions under which a schedule extension is allowed should be precisely spelled out. Weather or even delays caused by the owner taking time to make decisions about selection of products. But remember, time is money whether it's an allowable delay or not. It still costs money. The weather and the owner are two common causes for delays. Let me talk about that. An example of an allowable delay could include inclement weather or the time spent by an owner to provide something without which the project cannot continue, like approval for finishes. Or the owner might not provide access to portions of the site that the contractor needs to get to do his work. So to avoid an abuse of owner delays, the contract should establish a protocol for the contractor to request information and place the burden on the contractor to make a timely request for information to give the owner enough time to respond. To avoid abuse of weather delays, the contract should require the contractor to provide notice to the owner on the day that weather prevents work on the site, rather than waiting until the end of the project to claim weather delays when the weather conditions are difficult to verify. The fifth and last pitfall that I want to talk about today is called incomplete closeout. Now, this pitfall can spell disaster even for projects that had few problems during construction. For reasons not yet explained by construction science, owners and contractors often have a hard time letting go of each other. I know it's hard to believe. There are some steps related to project closeout that will help give the project a happy ending, though. First, include a retainage provision in the contract. The contract can require the owner to retain a percentage of the payment requested by the contractor. This retainage protects the contractor and the owner from the condition where the remaining work costs more than the remaining funds. Obviously, this portion is less desirable, or this position is less desirable for the owner than for the contractor. That is, having retainage held back. Contractors don't like it, owners do. It protects the owner. Although in the long run it can protect the owner from default. Sometimes a contractor is tempted to offset this retainage by front-end loading its payment request. The front-end loading is the practice of requesting payments early in the project which exceed the contractor's actual cash outlay. That helps the contractor's cash flow. The contract should limit the amount of payment that the contractor can request for upfront costs, such as mobilization, insurance, field office setup, and other early costs that do not result in visible work on site. Next, a punch list should be prepared that is reasonable. Many contractors call a punch list a wish list. This is an example of owners having a hard time letting go of their contractor. They see so much work that they'd like to have done, and a lot of it does exceed what the contract intended to deliver. So at the end of a project, a punch list should be developed that definitively outlines all remaining work. A good punch list has two characteristics. First, every item on the punch list must specifically describe the location and the work required at that location. For instance, a phrase like touch-up required on walls should be replaced with a phrase like compound sand, prime, and paint the wall beside the light switch plate at door into room 104, for instance. The second thing is that a punch list must not be prepared before the project is substantially complete. Substantial completion can be defined as when all project components are in place. For instance, it should be obvious that a project is not substantially complete if flooring is not yet in place. So if a contractor requests the punch list while the building still has an exposed subfloor, it does seem like it would be simple just to have the words install flooring throughout as one of the punch list items. The problem with such a line item, however, is that the punch list cannot include other line items such as replace the chipped floor tile in the floor that hasn't yet been installed, or remove the mastic from the carpet at the entry to room 117. You get the idea. It's not possible to evaluate the quality with which something has been installed if it has not yet been installed. So the goal of a good punch list is that on the next trip out there after the punch list has been established, the punch list should be getting shorter each time, not longer. Waiting until substantial completion contributes to this goal. So those are the 5 pitfalls that I see, and I have no doubt that you may be able to relate other pitfalls that you've encountered in advising your clients. So I want to thank you for joining me in this discussion and remind you that my advice has been strictly from the point of view of a design professional. Any provision in a contract has broad consequences and must be integrated into the contract under the guidance of counsel. Contract provisions should address the particular goals of each construction project and should be fashioned as a collaborative effort between both prospective parties to the contract, with the aid of respective counsel, to afford appropriate levels to each of advantage and protection. Well, I appreciate your time today, and I'll invite you to ask any further questions you have about what we've covered so far. I also wish that all of your clients' construction claims will be either preventable or winnable. And now I'm happy to take any questions that you have.
Thank you, Bob. I had a question posed to me during the last presentation of content. What are some examples of stored materials that should not be included in a progress of payment?
Yeah, a good example of stored materials would be, in general, anything that could be used on another project. For instance, stockpiling 2B stone on the project site. Well, that might get put into the project, or it might just end up on another construction site, and the owner should not be paying for the privilege of having his property used as a staging ground for other projects. Instead, that 2B stone should be counted only when it's put down on the paved areas and compacted in place. Then it's certain that that will be incorporated into the project. Likewise, bulk lumber or sheet goods like plywood or oriented strand board, all of that could end up on another construction site if it's just stockpiled in bulk on your client's construction site.
Okay, we have a question from Edward who asked, what about delays by an architect leading up to the construction documents in relation to the bidding process success?
I'm sorry, I missed the first part of that. I must have had a bad connection.
Oh, I'm sorry, Bob.
What are the ways?
What about delays by the architect leading up to the construction documents in relation to the bidding process?
Yes, so the question is, what about the architect delaying the construction project? Now, specifically during the bidding process, is that what you're seeing there, Matt?
It asks in relation to the bidding process success.
Yeah, I'm trying to understand if that question is very pointed or if it's just in general about construction. I mean, there are ways that construction is delayed by the architect.
Could you give us some example of how an architect would delay leading up to the construction documents?
Yeah, let me answer the way I think the question is going. During construction, there are plenty of ways that architects hold up the project because the architect plays a role in reviewing material and giving approvals for submittals such as shop drawings and manufacturer's data. So the antidote to that is to state clearly in the contract that the architect has X number of days to turn around an approval for a submittal that the contractor makes. Likewise, requests for information should be attached with a limited number of days that the architect would have to respond to a request for information. That's related to the construction phase portion of it.
Okay, there was a clarification made by Edward who said, I meant the docs aren't completed with appropriate detail. So he was talking about the preparation of the construction documents by the architect.
Yes. So if detail is missing in the drawings, Edward, then that could cause delays as well as costs. For instance, we use the example of roofing that is specified, but there are no flashing details, and there are plenty of places where it needs to be flashed. That leaves the contractor in a position to get those details from the manufacturer or to ask the architect to supply that information. In any case, that's a stopping point in the project that causes delays.
Excellent. Trying to think. I believe we have one more question coming from Norris. But Norris, you have your hand raised, but you could use the chat feature to actually submit your question. I can get it to Bob. In the meantime, just one more question that's coming here through the chat. What is a reasonable amount of retainage?
Yeah, normally, and I say normally, I'm used to using the AIA model contracts. So a typical retainage regimen would be to withhold 10% up to the first half of the construction project. Once 50% of the construction has been paid, then there's no retainage, so that by the time you get to the end of the construction, the owner is holding 5% of the cost of the contract back. That 5% can be used as incentive for the contractor to get finished up.
Okay, we have another question that came in just now from Richard who asked, what is the best way to manage the change order process to make sure change orders are completed and fully executed? Yeah, there are
a lot of different combinations. Although the AIA standard contracts have a protocol for the change order process, and it works fairly well for most sizes and types of projects. The first step would be that the need for a change is identified, and that need can be identified by any of the three parties. Once it is identified, it is put in writing to all parties. When I say the three parties, I mean owner, contractor, and architect. So let's say that the contractor comes out to the site and sees that two parts of the project just don't fit together. We've got an 8-inch block wall coming into a 4-inch block wall, and they just don't tooth together. And he says, well, if we just used 8-inch block for the rest of this wall, we'd be fine. That's my idea of what needs to be changed. In any case, something has to change because it doesn't fit. And so he puts out the question to the owner, and the owner uses the architect to identify that there is the change. So that's step one, that the need for a change has been identified. The next step is that a change directive is issued by the architect. The architect sits down with the owner, sometimes sits down with the contractor and the owner, and says, okay, here's what here's what the problem is, here are a couple of solutions I can think of, what do you guys think? And then a change is agreed upon, and the owner then issues a letter to the contractor through the architect typically, saying, okay, contractor, this is the change that we want you to make. So now the contractor's in a good position. He's been asked to make a change. The next step then is for the contractor to issue a change order. A request for a change order. So the contractor then says, I've been directed to make this change, and it's going to cost me so many dollars. It's going to cost me so much time. So this request for change order form or letter that the contractor has used has three things identified. Number one, the change to work. Number two, the change to dollars. And number three, the change to schedule. Once all three, work, money, and schedule, are identified, then the owner and architect can confer and decide if they like it. Or they may negotiate with the contractor and try to get the cost or the schedule or something to change about that. And once all that's done, then the last step is to issue the change order. And that is issued from the owner to the contractor, usually with the help of the architect. By the time the change order is issued, ideally all the negotiating has stopped. The work, the money, and the time has all been identified and pinned down and agreed to by all parties, so it's just a matter of signing and going forward. Now, most contracts will require work to proceed on schedule while the change order is being negotiated, or while the change order process is being negotiated, that 4 steps that I just outlined.
Excellent. Thanks, Bob. We do have a question from Norris now who asks, although change order process in the AIA contract requires owner approval, oftentimes the work is either approved orally by someone, whether authorized or not, or worse, done without the approval and sought after the fact. With time constraints, how best can you protect yourself against this practice?
Yeah, and again, that's something that even though a contract may have that 4-step change process that I just described, there will be some changes that somebody recognizes a need for and just doesn't think it's an important enough change to document it. And the best way to guard against that is for the owner to make a decision up front, or the contractor or the architect to make a decision up front that they will not tolerate that, and to get all parties to the contract involved or on board in the beginning, saying that I agree to do this, and if I see something that got changed without my knowledge, if in the case of the contractor, if somebody's directing the work other than the contractor, there's a big problem there. Then I will take action, and it takes a commitment on the part of all parties to the contract. Typically, that's not a commitment that's very hard to get everybody on board with, because it, even though the paperwork is a little bit bothersome, it becomes minimal compared to what we call horse trading developing, where there's a lot of changes that are undocumented to the project, and nobody really knows where the balance lies in how much more money has been spent or how much money has been saved from all these changes.
Okay, we have one final question from Edward, and then we'll wrap it up. Thank you for everybody who's been on the line the entire time. I think this presentation has been great, and to Bob, thank you for your time as well. Edward asks, is there some rule of thumb in the industry of the rate of cost of the construction? How much does construction cost escalate each year? Is there a rule of thumb, or is it kind of whatever the market can bear?
Yeah, good question, Edward. And there's so much variability in construction cost from region to region, as well as from one month in the year to another, that a lesson for me as a design professional is that when the owner says, how much am I going to pay, I have to claim ignorance and lead them toward a process where we get enough on paper to get qualified contractors to give actual bids, because it really is something that that varies from month to month and from region to region and from market to market. Now, the question you've asked, Edward, is how much does it escalate? And the answer is it's always going up and down. And but typically it has, what I've seen over the past 20 years is that it has not been ahead of inflation. We've seen some areas where it really took off, like after Katrina, and when the oil prices started to go up. Usually it normalizes itself. After that, it has, in my experience, has not been ahead of inflation.
Okay, great. Thank you, Bob. We're going to wrap things up here. Again, thank you for everybody who took an hour out of their day to join us this afternoon. I thought this was a great presentation on construction contracts. I apologize for the technical difficulties at the beginning, but hopefully you were able to enjoy this presentation in spite of those. Bob, I want to thank you for your time. You put together a great presentation. I know a lot of time and effort went into it, and I thank you for that. If you'd like to speak to Bob about a project or case that you or one of your clients is working on, please feel free to give us a call here at TASA. Our number is up on the screen. It's 800-523-2319. We will be sending out a link to the archived recording of this webinar later this afternoon. In that email, I will attach the PowerPoint presentation used by Bob during the event. We'll also post the archived recording of this event in our Knowledge Center. That's where we keep all of the webinars that we do for clients. So please check out the Knowledge Center of the TASAnet.com website. Our next client-focused webinar, Tractor Trailer Investigations/Reconstructions for Attorneys, will take place on February 4th, 2010 at 2 p.m. Eastern Time. If you did not receive an invitation and would like to join us for that event, please send us an email. My email address is up on the screen. I'll also email it out to every one of you. If you have any follow-up questions or comments for us, we appreciate your feedback. Please email me, but also remember, we'll ask you to fill out a survey after you exit this event. So on behalf of everybody here at TASA and our expert, Bob Illo, I thank you for your time, and we look forward to working with you in the future. Thank you.